Good afternoon, everyone. On behalf of Law Foundation and Legal Aid BC, I welcome you all to today's session. My name is Baljinder Gill. I'm the Community Training and Outreach Coordinator with Legal Aid BC. Before we start the session today, I would like to begin by acknowledging that the land on which we gather today is the traditional unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, Tsleil-Waututh First Nations. I'm also thankful to Anna and Alessia, who are providing all the background support, the tech support to this session today. Without them, we are not able to deliver these sessions. All the questions and answers, please write them in Q&A box, and we will access the questions and answers from time to time during the presentation. So it's my privilege to welcome again the two wonderful people who want to share their knowledge with all of you again today is Kevin Love and Isaac Won. Isaac is a lawyer in community law program. During law school, Isaac extensively volunteered with students' legal advice program, providing legal representation and advice to low-income and vulnerable individuals. Along with Isaac is Kevin Love. Kevin Love is a community legal assistant, is a lawyer with Community Legal Assistance Society, primarily working in the areas of mental health and workers' rights. Kevin has represented clients at all levels of courts, both provincially and federally, including Supreme Court of Canada. So please join me to welcome Kevin and Isaac. Thank you to both of you.
Hello and good afternoon, everyone. As was outlined, we're going to be talking today about SST appeals. However, we're going to go a little bit broader and really talk about start to finish how to challenge EI decisions overall. As a lot of people know, the SST does not just EI appeals, it also does CPP appeals, OAS appeals, and a lot of different federal benefits. We're going to be focusing on the process for challenging EI decisions, but you know, if people do have questions about how to adapt it for CPP appeals, we can do our best to get into those. So again, you know, one of our motivations for doing this is because there have been a lot of changes that have made EI a lot more accessible to a lot more people. Right now they're temporary, but we do hope that some of the temporary changes are going to lead to long-term changes that might make EI more accessible to people, which is a good thing, but it means that advocates who aren't doing that much EI now may be put in a situation where there might be increased demands from their clients for help with EI decisions. So the purpose of this isn't to go into the substance of EI law. You know, we'll bring up a little bit of it to try to do some examples and highlight some points, but the purpose of this is more the structure for how to challenge an EI decision and how you might go about finding information about the underlying EI issues. So with that in mind, Isaac, you want to flip us ahead? So here's what we are hoping to do today. So we want to look at the different stages of the reconsideration and appeal process and go through that so you understand what's involved with representing a client at each stage. We're going to look at how ensure you're effectively representing your client and sort of some practice tips. And finally, we'll try to look at some resources that are available, because obviously, you know, you're getting near the end of these presentations and you've had so much information lobbed at you that really a lot of this is about sort of having little inklings in the back of your mind and knowing how to research the problem or how to go find resources that'll help you in the future.
So just broad strokes, the overall structure of the EI claim process and how you sort of get from your very first initial claim from EI, it more or less looks like this. So you make a first application for EI, decision is made about that. The next step, if that doesn't go your client's way, is to apply for reconsideration of that initial decision. If that still does not go in your client's favor, the next step is to go to the SST General Division. And if, once again, the decision is made against your client, in most circumstances, you will need to request leave to make an appeal to the Appeal Division. And if you're successful in your leave application, then the Appeal Division is your last step short of judicial review in terms of having the EI claim adjudicated. So we'll start from the very...
Can I just say, just by way of background, just so people know, a lot of people hate this process quite rightly, and there's a big push on to change it, and that is probably going to happen. In fact, it will happen. So we're teaching you all this now, but don't be surprised if we're back in the spring or fall of next year telling you all about a brand new appeal process. So that's a great thing to say at the start of a presentation, isn't it?
Right. So the first decision about the EI claim, it's administered through Service Canada. You can apply for EI online. I don't believe that this goes through the My account that's available for CRA and other services. I believe this is a separate website, sort of flip through, you click boxes and go page to page. But that's the first step to getting the EI claim in the door at all, to see if it will be accepted or not accepted at the first instance. If that doesn't go your client's way, the first step is a reconsideration. And so this is, again, you're not yet at the SST, you're still at the commission level, and you're asking the commission to reconsider. Your deadline to apply for a reconsideration is 30 days from the first communication of the decision. And it's important to note here that communication can come in a written form, but it can also come in a verbal form. The commission can simply telephone your client to advise them that their claim has not been accepted. And that date is considered the first date from which your 30-day deadline begins to run. So it's important, if you are assisting a client with this process, not to strictly rely on a written decision for calculating that date, but to also make an inquiry about whether there was any verbal communication of the decision prior to the written decision. Frankly, with a timeline this short, in most cases, I think your best practice either way is going to be get your client filed sooner than later. That is done using this specific form that we've identified here, the request for reconsideration form. Your client does need to sign a consent form, consent to disclosure and or use of personal EI information in order for you to represent them. As far as we are able to tell, you can send the request for reconsideration by mail, or you can submit it in person. And for an in-person application, you need to make a service request due to COVID-19. If anybody is aware of any more convenient ways of doing this that have been instituted as a result of COVID, please do speak up. But that's as far as we can tell. This is the process for making reconsideration applications. These forms are available online. The catalog of forms is a little bit awkward, but if you rely on these numbers, these form numbers here that we've given you, you should be able to find these forms without too much difficulty. And I thought I saw we have some, no, we don't have any questions yet. Okay. So one thing you are going to want to do with regard to the reconsideration is request the file that the commission has. And the commission may not give you all the information on the file. Your client may not actually know what all the information in the file is either. In some circumstances, the commission may have had a conversation with the employer or otherwise received some information that your client may or may not be fully aware of. So if the commission tells you that there's information on the file that they are not going to give you, you can and will have to make an accessed information request. This is also known as an ATIP request. If you need to do this, do it right away, because it will take some time for that to all be concluded. And obviously you want to have all the information to inform your clients best practices going forward as soon as you can.
And Isaac, we should, just to clarify the term commission, you know, as Isaac said at the outset, most of the time you're dealing with this thing called Service Canada, which is really, you know, something they've created to give a bunch of information and administer a bunch of different benefits. In the background, the actual decision maker is this division of ESDC called the Commission. And so when we talk about commission, that's who's making the decision, even though practically on a day-to-day basis, you're dealing with Service Canada centers and Service Canada call centers.
Right.
And we do have a question, it looks like. So we have a note, our Service Canada office has been closed for several weeks now with a sign that explains closed due to unforeseen circumstances, which seems a bit cryptic. So online seems the only way to file other than mailing things to offices indicated on their website. I was really searching for any, you know, I think the SST has been forthcoming with a lot of their modifications in light of COVID in terms of confirming that you can deal with them electronically. I can't really find that much from the EI people about dealing with reconsiderations. You can make the initial application online, but how to file a reconsideration electronically. But if anyone has had any success, you know, emailing, faxing, or otherwise getting a reconsideration request accepted electronically, it would be great to post that to the chat or to the Q&A, because mailing is obviously awkward and takes time, and if the office is closed, what can you do? I do think Isaac's going to cover, there is a way to make a service request, I believe, but I think I'm jumping ahead.
Yeah. And I guess just one last point on this requesting the file process. Our understanding is that this seems to be informed by some interpretation of privacy legislation that the Commission thinks prevents it from disclosing information about third parties. So that's sort of, you know, that seems to be the reason why the Commission is requesting participants go through this a little bit more sort of complicated process to get to those documents. So the reconsideration decision does not involve the convening of a formal hearing. The Commission will usually call the applicant to give the decision, especially if the reconsideration is denied. They usually will also get a decision letter in writing. Reconsideration decisions tend to be pretty scant in terms of the detail that you get in the written decision. From what I've seen, they basically say, we've reconsidered your claim and we are denying your claim because the Act says so. And that's about as much as you get. But you obviously still need to go through that process. There are a few decisions that can't be reconsidered or appealed. Just as sort of a side note, a decision where the Commission refuses to write off or forgive an EI debt cannot be reconsidered or appealed. Certain discretionary decisions about employment benefits, which are training benefits, also can't be reconsidered or appealed. Another interesting factor in this is that there are certain decisions that are very much relevant to EI eligibility decisions that are not, in fact, these certain issues are not actually adjudicated by the commission. They're decisions made by CRA. So issues about how many hours a person worked or earned, when their employment started and ended, and whether their work is covered by the EI system are actually issues that sort of get hived off and sent over to CRA to make a decision about, which can lead to some confusing circumstances for people trying to navigate the system. They think that, reasonably think that the commission has made these decisions about their employment when in fact it wasn't the commission, it was CRA.
And we'll circle back to those if we have time at the end. I just wanted to jump in with one comment about the first bullet, just so people don't get confused. You can absolutely reconsider or appeal whether you owe the debt in the first place. That's fine. So don't think you can't reconsider or appeal a penalty, a debt, whatever it is. This is just, there's a process where you can write in and say, okay, I was overpaid EI benefits, but for this reason or that reason, I think you should forgive the debt, because even though I technically didn't qualify for these reasons, I shouldn't have to pay it back. If they refuse to forgive the debt, that can't be reconsidered, but you're always free to appeal that you just don't owe the money in the first place.
And Kevin, would you be able to file for judicial review on the first 2 points we have on the screen?
I've done it. It didn't go well, but yeah, I think theoretically it's a final decision, so you can do it, but
right.
It's a pretty difficult task because they're very part of the reason they don't want them to be reconsidered or appealed is because they're very discretionary. So which maybe they shouldn't be, but the fact that they are makes them hard to review. Yeah.
Okay. So just briefly to sort of diagram how you end up at the appeal division. Again, EI claims are going to come from the EI section of the general division. Other types of claims are going to come from the income security section, but they both end up at the same appeals division of the SST.
And the income security section is the one that deals with OAS, CPP, GIS, those types of federal benefits.
So getting to the general division, your deadline to appeal again is 30 days from when the recon decision is communicated. Extensions are possible, but not past 12 months after the decision was communicated. Practically speaking, you generally do not want to have your client in a situation where they are asking for an extension, just as a matter of meeting any sort of legal deadline. But that's your possibility if they don't meet that 30-day deadline. The notice of appeal, which is the form you fill out, is available on the SST website. Frankly, just a Google search of SST notice of appeal will probably get you to that form or to the online repository where you'll find that form. This form can be sent by mail or fax or email. One important thing to note is that your appeal package must include a copy of the reconsideration decision. If your notice of appeal is incomplete, if it is missing that reconsideration decision or some other important information, the applicant should get a letter setting out a timeline to provide that missing information. And if the deficiency in the information is resolved within that timeline, then the application goes ahead. One thing to also note is that the employer also has the ability to appeal to the general division from the decision in relation to the one of their employees' EI claims.
So that bit about the reconsideration decision, one of the first questions you're going to want to ask your client in an EI matter is to get copies of decision letters, because obviously you want it just for your own information, but also it's a requirement to appeal. So if they don't have it, tracking it down can be a bit of a problem, and it really is necessary to complete the appeal. So you want to get that, you want to ask that sooner rather than later.
So the General Division requests the file from the Commission, so the sort of underlying information in relation to the decision to, say yay or nay on the benefits being provided. This usually takes 7 days, and they will send them to the parties. So you should receive a copy of the Commission file. If there's evidence that's already in the Commission file, you don't need to resubmit that. You can submit new evidence for your client. There isn't a specific deadline to do that, but your hearing might get adjourned if you are sending in evidence too close to the hearing. If you don't get documents into the General Division in time, the tribunal may simply exclude or refuse to consider those documents. So it's important that you do get them in at absolute minimum before the hearing, but you probably want to give a little bit of breathing room at least to make sure that you don't have any issues of disclosing documents too late. The General Division obviously is going to send all communication and any new evidence that you submit to the other parties in the proceeding as well. So the representations of the Commission are that's basically the term that is used as sort of the pleadings or the submissions submitted by the Commission, basically setting out their reason why, if they are opposing your appeal, why your appeal should not be successful, or if they're consenting to it, which apparently they do sometimes, why they agree. These are very important because they are often going to be one of the first really fulsome explanations of why the Commission decided to do what it did. Again, the reconsideration decisions often have very little information. So this is helpful to you because it will give you a sense of what you want to address in your submissions, because this is sort of the first time that you're really going to get likely going to get a good sense of what the Commission considers relevant and important in the decision. And you can send documents and submissions in response to those, to the representation once you receive it.
So, it's a good idea when you file your appeal, if you have stuff that is relevant, you can file it right with your notice of appeal. But that doesn't end it. If you read the representations and you figure out that other documents or information from your client is relevant, you can continue to send things into the SST. I'm sure they appreciate getting things in packages rather than like a document every day. But like Isaac says, you can read these, and even if you've already sent in documents with your notice of appeal, you can send in more to try to address once you have a better understanding of what the Commission is trying to do.
And Kevin, do you know, is there a specific point in the processes at which you receive these representations, or is it just some time before the hearing happens?
My understanding is they usually send them out with the file from the Commission. So when you file your appeal, the SST is going to go to the Commission and say, give us your file about this decision. And with that file, my understanding is that the Commission will attach to it their explanation of their decision or their representations about the decision, and that'll all get sent to you. So you should have it fairly early in the process.
Deemed receipt of documents. If you send documents by regular mail, they are deemed to have been received 10 days after the document was put in the mail. If you send a document by registered mail or by courier, the document is deemed received the day someone signs for it, or it is successfully delivered to the last known address. I suspect for an employee representative, this is more relevant potentially if you're delivering documents to employer. But you can also send documents by fax or by email, which are deemed received after the next business day after they are sent. The General Division can dismiss an appeal without a hearing if it has no reasonable chance of success. This is called a summary dismissal, and it's sort of like a shortcut in the process that the General Division can take if they, on their review of the materials, are of the view that your client's applications just simply doesn't have a reasonable hope of being successful. If this happens, your client will get a letter stating that this is what the General Division is intending to do, and you also get a chance to explain why the appeal does in fact have a reasonable chance of success. So an example of a situation where a person has no reasonable chance of success is if they, in their application, admit that they don't have enough hours in their qualifying period to qualify for EI, but they think that they should get EI just because for some other reason it would be fair for them to do so, or they are having a particular hardship that is resulting in them having a considerable need for EI. Unfortunately, these aren't relevant factors in terms of the question of one's eligibility. So that's an example of a circumstance that probably would be dealt with through this summary dismissal process. So assuming you get past the summary dismissal stage of the process, you'll get a notice of a hearing. Hearings can be held in person, by video, which are now being conducted by Zoom. Previously, you had to actually go into a commission office to sit down at their computer and use their video. It seems like they're now pretty much fully transitioned over to Zoom, and we hope that it stays that way, although I suppose there's no way to know for sure. Hearings can also happen on the telephone, or they can happen through written submissions. The SST will provide an interpreter at the hearing if you need one, but they won't provide any translation of documents. So if that's a service that your client needs, they may need to arrange for that. In your notice of appeal, you can actually request a hearing in French or in English. So that's another option in terms of an interpreter. The entire proceeding can be held in French or English.
And the SST has actually done, to their credit, a lot of work to try to improve their documents. And the notice of appeal now actually provides space to ask for a lot of these things. Like you can ask for an interpreter. If the client needs accommodations, you can actually ask for it right in the notice of appeal. You can request what type of hearing you want to have right in the notice of appeal. So they've made things a lot simpler, and the notice of appeal, we're not taking you through it because it's fairly intuitive, I think.
If you, we can talk about adjournments, but I think just to be clear about this, the way in which these hearings are scheduled is that the General Division is not going to canvass your availability or the employer's availability. They are going to pick a date and let you know that you have been given a specific date, and that's when your hearing is going to happen, unless you ask to reschedule within 2 business days of getting the notice of the hearing. You don't need to provide any sort of reason for that. It's just, the idea is this date has been picked without canvassing your availability. So if you are not, if you or your client are not available for that date, you don't need to justify not being available on that date. You just need to let them know that it doesn't work for you, and they are the General Division, will then schedule the hearing on a different date. So you need to be aware of that 2 business day deadline. If that is the case, you can just simply call to ask for a rescheduling, but because there's this timeliness issue, it's probably best to send a written request as well, just so you can prove that you got your request out within that 2 business days timeline that you need to meet. If you don't ask for a rescheduling within those 2 business days, you have to ask for an adjournment in writing, and you need to explain why you're asking for your adjournment. That is something that it seems like they are reasonably generous in giving adjournments once, but asking for an adjournment more than one time is going to require some exceptional circumstances in order to be successful. If you do call or write within those 2 business days for a rescheduling, that's considered a rescheduling. So that doesn't count as one of your 2 adjournment applications. So it's only if you are asking for a different date after those 2 days elapse that is considered an adjournment application. The hearings themselves usually last an hour. They loosely follow a trial format in the sense that each side gets to say their piece. It's a little bit less formal. There is attendance and examination of witnesses. They're asked to take an oath. They can be questioned by the tribunal member. They can be questioned by any of the parties. Those of you who are already practicing at administrative tribunals are probably mostly going to be sort of familiar with how this works. It's not going to be too different from anything that you've already seen.
It's going to function a little better than your average RTB hearing. Like, I think it's still that idea that there is loosely a format, but it's supposed to be much less formal without a lot of the legal trappings. But it's probably going to come across, for those of you who don't do a lot of these, as a little more structured than an RTB hearing, which is probably a very good thing in a lot of cases, but still not overly formal.
Decisions will be made in writing. They are anonymized when they are published. I don't believe all decisions are all general division decisions publicized?
I'm not sure all general division, all appeal division are. I think only select general division are right now.
So there, in either event, if it does get publicized, the decision is going to be anonymized. They have their own service standard, 45 days within the appeal being filed. That's when they try to make their decision. They also try to make their decision within 15 days of holding the hearing. So here, what we're going to do now is we are going to look at a sample decision. This is an actual general division and appeals division decision chain. So this is a real life example, just based on publicly available information that we're going to go through. So Kevin is going to take us through this.
Right. So to start, again, like Isaac said, we're actually going to try to use a real decision, so that if there's any keeners out there, we put some paragraphs from the decision, both levels of appeal, in the slides, but the keeners, the citation is there, so you can go read it to sort of get an idea of how it works. So the client in this decision was AK, and I'll say it's not one of our clients or anybody I know's clients. This is all just based, like Isaac said, on stuff we extracted from the decision. But before we get to that, let's say this client AK comes to your office. She says she applied for EI but was denied because she quit her job. She says she asked the EI people to change their mind, but they wouldn't. She now wants to know what her next steps are. So using the chat, everyone's been very quiet. If you just want to type in some ideas about, just at a preliminary level, without getting into the details of her case or whether she's going to win or not, what information or documents are you going to want to assess her options and her deadlines? Absolutely down there. You're going to need to get into why she quit for sure. Yeah, yeah. Immediately you're going to want copy of letters. Absolutely why she quit is going to be critical. But the original decision, the decision letters are going to be very, very important. And the reason the decision letters are going to be important is twofold. A lot of times clients don't really know if they've formally asked for reconsideration. Like if they're not familiar with the process, it's like, I talked to some people called, I filled in some paperwork. Often it's unclear if they've actually applied for reconsideration or not. So you're going to need the letter to actually understand what stage she's at. Is it an initial decision or has she been applied for reconsideration? But either way, you're going to need that decision to attach to actually apply for the next stage because, to appeal to the SST, attaching a copy of the reconsideration decision is mandatory. So you're eventually going to need that anyways. And then someone else has noted it's also important for calculating the deadline. So it's 30 days, but one of the things to remember for some of you who may be used to some provincial timelines is that it works from the date of first, right? And so, yeah, for all of you saying in the chat that to assess the 30 days deadline, you're going to need to know when the decision was communicated to her, and that's critical. Often, like we said, the reconsideration decision is often woefully devoid of anything useful in terms of understanding the case, but it is going to help you understand your next steps and your deadlines. So good stuff there. And all the other documents as well that are mentioned, like an ROE, that's always good to see. I always like to see an ROE. It confirms hours, but also it's the employer's account of things in terms of the reasons for separation. So, while it's not essential in the sense that you need it to appeal, it's going to be something you're going to want to see. So, it's a good thing to ask for, certainly. Okay. So, so at this point, if you want to flip, what we're going to do is take about 5 minutes here. Oh, sorry, before we go, we got a question. What if employer refuses to reissue the ROE? So first thing to know about ROEs is that most of them nowadays are submitted electronically, which means that you're not going to get a paper copy of them, and nor does your client need a paper copy to apply for EI. They're submitted electronically. They can be accessed through the online Service Canada account. Service Canada has them. So that's all well and good. If the employer does not electronically file, then they're supposed to give your client a paper copy. Now there's a problem where some employers just don't give an ROE. They're just shady. They don't follow the rules. They don't give your client an ROE. And so what you're going to want to do there is help your client. The commission is going to want to see that you're making efforts to get the ROE. So document your efforts to call the employer. I would send a letter to the employer, send a follow-up letter. But the key thing to know with ROEs is don't use not having an ROE as a reason to miss any deadlines. Just apply or reconsider, do whatever you have to do. Waiting on an ROE and missing deadlines isn't a good idea. If push comes to shove, and despite your best efforts to get an ROE, the employer just won't give one, then it's possible the commission will get involved in trying to get it, or there are other ways they can evaluate the claim. They might ask you for other information like pay stubs or stuff like that to try to piece together the claim. So step one is for you to help your client contact the employer to ask for the record of employment. I do it a few times, but again, keep meeting your deadlines. Don't miss them. Okay, so what we're going to do now is, because of all your excellent questions, you got all your excellent questions. You got your SST appeal filed on time. You found out it was a reconsideration decision, and therefore you helped AK appeal to the SST General Division. You filed your appeal. Shortly thereafter, you got the file, and it contained representations from the commission, which we are now going to post to the chat. So if everybody can just open the document that gets posted to the chat, we'll take about a 5-minute break so that everyone, it's not terribly long, but everybody can just give it a read through. And again, I'll emphasize, this is not real. This is something we have pieced together based on the written decision and the facts reported in the written decision and the decision's account of what the commission was saying. So we're not publishing anything from anybody's EI file in case anyone's nervous. We have completely invented this. So so with that, we'll take about a 5-minute break, and everybody can just give that a quick read through, and then we'll come back and talk about it here. So hopefully everyone's had time to read it. And again, using the chat, if you can, what information or questions, again, remembering that this is just the commission's view of the world. What questions might you have for AK in assessing this appeal? So if anybody's got any ideas, use the you can use the chat to put them up. Yeah, great question. How much were your hours cut? Yeah. Yep. Any proof of the other offer of contract work? How significant was the reduction in hours and salaries? Yep. Ask question whether the likelihood of her getting the other job is reasonable? Yep, absolutely. These are all great. Did she have a written agreement with her employer regarding shifts, scheduling, and time off contract work? Does she have anything in writing that the employer offered to accommodate contract work? These are all great questions. Yeah. The employer's practice and about booking time off. Yep. Yeah, these are all great. So Isaac, do you want to flip ahead here? So here's an answer to some, though not all your questions. And if we can't answer some of the excellent questions you posted, it's because there just wasn't information about them in the decision. But so here's a little bit more about what AK tells you. AK tells you that there was a staff meeting where employees were told to expect their hours to be cut. Part-time staff, which she was, should expect their hours to be cut first, possibly to 0. Recently, she was cut to 2 shifts per week, even though she was hired to work 4 shifts per week originally. She says that her relationship with her employer was not too bad outside of her boss refusing to give her this time off to do the contract. And she thought that the short-term contract would lead to long-term employment. So again, using the chat, you'll see down at the bottom of the commission's submission, and they will usually do this. They've put the relevant legislation, the sections of the act that they think are relevant. And in this case, if everybody can find subsection 29C, it starts with the words, just cause for voluntarily leaving an employment. So it says, just cause for voluntarily leaving an employment or taking leave from an employment exists if the claimant had no reasonable alternative to leaving or taking leave, having regard to all the circumstances, including any of the following. Does anybody want to just fire into the chat which of those sections think could be relevant? Yeah. Okay. So 6, yeah, for sure. Reasonable assurance of another employment in the immediate future. Um, Significant modifications of terms and conditions respecting wages or salary. Yep, that could definitely be relevant. Under pressure by an employer on the claimant to leave their employment. It doesn't sound like the relationship was too bad, but it's definitely worth exploring. If this employer was essentially trying to force her out. Yep. Yep. And a lot of people are adding those significant change in work duties. Yep, absolutely. And I'm glad someone mentioned the all-important any other reasonable circumstances that are prescribed. So that section refers to ones that are actually prescribed by regulation, but it is important to understand that anytime you see a list that starts with the word includes, it means it's not closed, right? They're telling you to think about all the circumstances. These are some of them, but it doesn't necessarily mean all of them. So that's great to get your mind thinking that just because it's not on this list doesn't necessarily mean it's not relevant. Interesting question: practices of an employer that are contrary to law. Reduction of hours over 50% or more could be considered a termination. Interesting. I'm not sure. I mean, I think that might be more a violation of the contract as necessary versus necessarily against the law. But I like it, and this is exactly what you want to be doing, is to explore all these different factors. Because you might find something the employer's done that's contrary to law. So yeah, that's great. So that's awesome. So what we're going to do now is we are going to assume that based on all these excellent questions and research, you helped put in submissions for AK in her SST appeal. There was a time where Isaac and I were thinking like, why don't we actually have them like write out submissions? But you're lucky you're by webinar, so we figured that wouldn't work too well, trying to write an entire submission in the chat of a webinar. So we're just going to assume you did it. They were great submissions. And now we're going to look at the decision that came back from the General Division. And this is what we're about to show you is actual quotes from the decision. We didn't want to make you read the entire long decision, so we've kind of just pulled out relevant paragraphs. But again, we're going to tell you how to look up SST decisions later. So if you're interested in reading the whole thing, absolutely you can. Okay. So this is the decision you got back from the General Division. Paragraph 15, the law says that you have just cause to leave if, considering all the circumstances, you had no reasonable alternatives to quitting your job when you did. Then in paragraph 22, the law states that one of the circumstances to have regard to in considering whether the claimant had just cause for her voluntary leaving is a reasonable assurance of another employment in the immediate future. I find the claimant had the reasonable alternative of remaining in her employment at the fabric store because it was permanent employment rather than voluntary leaving for employment that was temporary. I find the claimant made a personal choice to separate from her employment. While I acknowledge her desire to want to earn more money, have a change, and to keep up her career, she cannot expect those who contribute to the Employment Insurance Fund to bear the costs of her decision to leave her employment in an attempt to do so. The claimant failed to pursue any of the above noted reasonable alternatives, and therefore she failed to prove that she was left with no reasonable alternative but to leave her employment. As a result, the claimant has not proven she had just cause for leaving her employment. So you lost. Great submissions, but you lost. So now you're angry, you're mad because the decision is problematic. But the good news is we can now turn to your next level of appeal. So don't worry, the story doesn't end there. You'll get a chance at vindication in a bit. So before coming back to our example, what we're going to do is we're going to run through the next level of appeal. So the SST is broken into two divisions, and they're quite different in terms of what they do. The SST General Division, as we just discussed, is pretty wide-ranging. They'll consider new evidence. You can make whatever submissions you want, and they're going to spit out an entirely new decision. The SST Appeal Division is a little different. That's not what it does. It's much more restrictive, and we'll look at how that works in the next few slides. So the first thing to know about the Appeal Division is there's no automatic right to appeal. You have to get what's called leave, which is essentially a stupid legal word for permission to appeal. So what that means is you have to file a notice of application for leave to appeal and convince them that your appeal has some reasonable prospect of success. Not that it's going to win, but that there's at least a chance of success. The only exception to this rule about getting leave is if your case was summarily dismissed. You get to automatically appeal without leave. And I think the reason there is because if your appeal was summarily dismissed by the General Division, that was because they found it had no reasonable prospect of success. So it would get into this weird situation if the SST Appeal Division was considering whether there was a reasonable prospect of success, that the decision that you do not have a reasonable prospect of success could succeed. It gets too weird, so they're just like, we're just going to consider whether there was a mistake. The deadline to apply for leave is 30 days after the SST General Division decision was communicated. And so SST-GD is just going to be the shorthand for General Division, the first division of the SST. The application form is on the SST website. And once again, you must attach a copy of the General Division decision you are trying to appeal. So again, one of the first questions you're going to want to ask your client in all EI matters is, get me decisions, get me all the decisions you have, because it's not only going to be important for figuring out what's going on, but also you can't complete the appeal without it. I should say two things. Number one, if you ever find yourself without the decision, it's still better to appeal and then make sure the appeal is on time, because if you don't attach the decision, they'll send you a letter giving you a time frame to send the missing information, so you can buy yourself a little time. Obviously, it's best to get the entire appeal filed properly if you can, but if you can't, it's still important to file something to meet the deadline and then just deal with completing the appeal later. But also with the General Division, it's a little easier because some of the decisions can be accessed online, and just generally the SST, I think, is a little easier to deal with in terms of getting decisions. And importantly, the Employment Insurance Commission and the employer can also seek leave to appeal, which can come as a surprise to a lot of workers when they win at the General Division, but they find someone else is dragging them up to the next level of appeal. So unlike the General Division, the Appeal Division's job is not to conduct an entirely new hearing, although it seems they're kind of going that way recently. But the Appeal Division can only get involved if they find one of a few very specific errors. And a lot of this language, you're going to start to think that sounds a lot like, a court appeals or court judicial review, and you'd be right. And this is one of the criticisms of this system, is that for a system that's supposed to be accessible to people, they're bringing in these complicated legal ideas that we struggle to understand and explain. And so how is an unrepresented person supposed to really understand this? So hopefully they're going to get rid of this. But as it stands now, you, rather than focusing just saying the decision is wrong, you have to focus on what the error is. So the first is that the General Division breached the rules of procedural fairness. And so again, this focuses on not the decision itself, but the process leading to the decision, and whether your client had a fair chance to know what the appeal was about, and a fair chance to say their piece. So, examples would be relying on evidence that your client never got to see, not giving your client an opportunity to say their side of the story. Maybe in some cases, it might be not giving your client an opportunity to question other witnesses. All these things can potentially make the hearing unfair. The next one is SST. The SST acted without jurisdiction. That, again, is just a fancy legal term for did something they didn't have the power to do, or something they're not supposed to be ruling on. So the common example that Isaac mentioned at the start was trying to make decisions about how many hours you had worked. So if, the record of employment said your client had worked 700 hours and the general division says, actually, I think you only worked 400 hours. That's not going to be something they have the jurisdiction to do. The general division erred in law. So this is going to mean that the general division either misinterpreted or misapplied the law. And the last one is a total mouthful. Decisions based on erroneous findings of fact made in a perverse or capricious manner or without regard for the material before it. That just take that to mean serious factual disputes. What this really means is the appeal division isn't there to redecide to believe this witness or not this witness, or to give more weight to this evidence or less weight to that evidence, or to decide they should have believed your client over the employer. It has to be a pretty egregious finding of fact that is pretty much divorced from the material that's actually in the record. And generally, there is no new evidence at the appeal division level. So generally, it's very important as one practice tip, and this is important, don't hold anything back at the general division, get it all in, because if you don't get it submitted at the general division, you're not likely to get it considered at the appeal division. So the first stage is the leave decision. So generally there's no hearing on this. They're either going to grant or deny leave to appeal. If they deny leave to appeal, that ends it. It's done, subject only to judicial review. If leave to appeal is granted, that doesn't mean you win. It means that you're going to get to argue your appeal fully and try to explain why one of the errors we talked about is in the decision. So again, the issue at the leave stage is not whether you have shown that the decision has one of those errors. It's that there's a reasonable chance you could show that there's one of those errors we discussed. And the timeframes at the appeal division work a lot slower. The rationale being the general division's purpose is to try to correct decisions quickly to get money into unemployed workers' pockets. The appeal division takes a little bit longer, and it's sort of designed to resolve cases once they've already gone off the rails. So generally, they try to make a leave decision within 45 days to either grant or deny. So if leave to appeal is granted, that means that the process is going to continue. You're going to have 45 days after leave is granted to file written submissions, though you can ask for an extension. There's no requirement to actually hold a hearing, although they often do. If there is a hearing, you'll get a notice of hearing. And again, the types of hearings they can hold are the same as at the general division. Could be by phone, by video. In some cases, they might, once we get through this pandemic, they might hold in-person hearings again, but it can be any one of those hearings. And as a practice point, again, at these appeal division hearings, it's very important to focus on the ground for appeal rather than just trying to re-argue the case from scratch. So really zero in on the errors made in the general division decision. They try to schedule hearings within 90 days after leave is granted. So again, the appeal division process is going to take a little bit longer to try to correct mistakes. So after you go through the process, you're going to get a decision. And of course, they can deny your appeal. And if that happens, that's it. Once the SST Appeal Division has denied the appeal, short of judicial review in the Federal Court of Appeal, FCA stands for Federal Court of Appeal, that's it. If the appeal is allowed, that does not necessarily end the case. And this is another source of frustration for a lot of people with this current system, particularly workers. The SST Appeal Division can do a couple of things. Often they will send the matter back to the General Division for a new hearing. And this can be really frustrating for workers because you win the battle, but you still have to go back and win the war. And that can cause some frustration. Increasingly, I think in response to some criticism from people who are being sent around and around, the appeal division can also just make the decision the General Division should have made if the appeal division thinks it's in a position to do that. That also has some shortcomings, given the fact that the appeal division doesn't generally take new evidence or hold full hearings about the evidence. So one thing is you're going to want to address in the course of your appeal is what you're asking the appeal division to do. And it's not often simple to figure out. There are some cases where you look at it and you're like, oh boy, I could really use another chance to build the evidence here, or the process was unfair, so I didn't get a chance to build the evidence or say my piece. And you may actually want it to go back to the General Division so you can do that, sort of fill in some of the gaps. There are some cases where you may say it might be beneficial to go back to the General Division and have another kick at the can. But the flip side is the impact of delay on your client. At this point where, your client has probably been without work and has been without EI probably for over a year. So, or it could be, maybe not over a year, but could certainly be close to a year. So the client may want to just get it done and not be put in this, this never-ending circle. So they don't have to agree with you, but you should address what you're asking the appeal division to do. Of course, you may ask them to send it back and they may decide, no, I'm just going to make the decision. And just so you know, you might be saying to yourself, well, if they allow the appeal, doesn't that mean if they're going to substitute a decision and make the decision the SST General Division should have made, that it would go in my favor? No, not necessarily. There are lots of weird decisions where the appeal division will say, yep, the General Division made a mistake, so I allow the appeal, but I'm going to give the decision the General Division should have given, which is still to deny the claim. Go figure. But that's a risk. And again, they try to make decisions no more than 60 days after the hearing. So what we're going to do now again is pause a bit to do another little bit of an exercise. So, we went through the example with AK and we read you some key paragraphs from the decision. And actually that's what that was. We're going to go over them again, just so you can reread them. And just, we'll take about, 2 minutes just so people can think about it. And I know this is a little bit hard to do in a chat function, but based on the paragraphs we're going to show you, if people just want to pop in their ideas of what you might put forward as a ground for appeal if AK wanted to appeal to the appeal division. So again, if you flip forward, Isaac. So this is what the General Division says. The law says you have just cause to leave if, considering all the circumstances, you had no reasonable alternatives to quitting your job when you did. The law states that one of the circumstances to have regard to in considering whether the claimant had just cause for voluntarily leaving is a reasonable assurance of another employment in the immediate future. So flipping forward, again, goes through, the General Division goes through and finds that AK's opportunity to do a short-term contract didn't constitute, a reasonable assurance of a new employment. She had a reasonable alternative of staying in her employment at the fabric store. Essentially, her decision to separate. Flipping forward. So maybe we'll just pause for a couple of just a couple of seconds. And if people want us to go back to the slides, we can. But maybe just give a little thought and post to the chat what you think might be some grounds, possible grounds for appeal to the SST Appeal Division. And just as a little hint, you can assume that we've given you some paragraphs, but assume there's nothing in the decision talking about her reduction in hours at the fabric store. Yep, so we have some people posting already. They didn't address the 50% reduction in hours and wages. And wasn't reasonable to stay at old job, perhaps income not sustainable. So that's all exactly right. Does anybody want to try to phrase it as, put your lawyer hat on and try to phrase it as a ground for appeal? What would you say the error is? Okay, so let's, so we've got a request to go back to the grounds for appeal. So let's, Isaac, let's go back a bunch of slides to where we talk about the different.
Is that section 29C that we're talking about?
No, it's the grounds for appeal to the appeal division. I think it's back about 5
Oh,
slides.
right. Okay, yeah, gotcha. Is that it? No, that's not it.
No, we're back one, I think. One more.
There we are.
There we go. Hopefully that's what you were looking for. So breach of procedural fairness, acted without jurisdiction, erred in law, and we have someone posting erred in law, and decision based on erroneous findings of fact made in a perverse or capricious manner or without regard for the material before it. So we have a couple of votes for error in law. So let's start there. How would you phrase the error of law here? Yeah, see, this is always the hard part, because I always just want to write on the paper, you done messed up, you fools, like you just got it wrong. But I'm trying to, try to finagle it into an actual ground for appeal can be tricky. So had just cause to quit as per section 69, that's where we want to get.
Yeah.
But what was the specific, is there a way to zero in? That's absolutely right. Is there a way we can zero in on what they didn't do? I like that. Okay, so there we go. Did not consider all reasons for just cause. So again, again, if everyone has the fact pattern in front of them, if you look at section 29, it says, considering all circumstances. And they didn't consider all circumstances. They considered one circumstance, but didn't consider all circumstances. Yeah, I like that. A couple of people are saying there's also an erroneous finding of fact. Has anybody found a fact they want to zero in on? I know it's a little hard in this exercise because you don't have the full record or the full decisions, but if anything, even if you're not sure, if there's something you want to explore, feel free to point out where you see the erroneous findings of fact happening. Okay, well, I mean, there are some findings of fact here, whether they're erroneous or not is, is difficult to say, but saying the claimant failed to pursue any of the above reasonable alternatives, finding the claimant made a personal decision to separate, those are findings of fact. Whether they're impeachable, I don't know, but they're things you could definitely look at. And then we had a question, is the failure to consider all circumstances error in law, a more error in law than erroneous finding of fact? Yeah, and this is one of the problems with this whole system and why we need to get rid of it, because it becomes a lawyer's game of trying to phrase things one way or another. And most things can be phrased one way or the other. Generally speaking, if you have the choice, you're going to want to go with error of law because there's no deference. There's no the appeal division has the ability to just step in and say you got the law wrong. So you're definitely going to want to do that. One of the things Isaac and I talked about, and we deliberately said we weren't going to cover it because we figured you would all just be clicking the leave meeting button immediately if we did, is go back, Isaac, to the go back to the grounds for appeal. Are you able to do that? Yeah. So what you'll notice is missing here is any ground for appeal for issues where the errors, where the issues of fact and law are all bound up, where you can't really separate them. It's a finding of mixed fact and law. It's a finding where, you know, you're saying this set of facts and I'm applying it to this law and reaching a conclusion. And because that's not listed as a ground for appeal, it does become a game of trying to phrase things as best you can as an error of law. So, you know, to the question, failing to consider all circumstances more an error of law than erroneous findings of fact, it may be possible to frame it as both. I would phrase it as an error of law. You know, basically saying, because it's more beneficial to your client to say the law says you must do this, you did not do this. That's generally going to be the way you're probably going to want to go, unless you can really, unless the issue is truly one of fact. You know, competing version of events. Now that I've confused things, Isaac, do you have anything to add to that, or?
I guess the only thing I would say is that phrasing this as an error of fact is just practically speaking difficult today because we didn't really set out a full factual set for you all in this exercise. So it's difficult, and, you know, depending on the circumstances, if you were able to drill down into it a little bit more with your client and really sit them down and talk about it, you know, maybe there would be some findings of fact that you might be able to get at here.
Yeah, no, good point. Yeah, someone's noted, you know, she had reason to believe she had found alternative employment. So, you know, you could also go looking at their application of that factor, right? You know, did they get the law right around assessing whether this was, you know, an offer of employment, you know, and looking at that, and we'll talk about some of the tools you can use to research specific issues. But these are all great ideas in terms of what you could advance for grounds for appeal. So if we go back down, we can look at what the appeal division actually did here. So here's some extracts from the actual appeal decision. So what the appeal division latched on to here was the issue of not considering all the circumstances. So all of you put some great ideas in the chat, and, you know, you don't want to be spamming things that have no potential of winning, but at the same time, sometimes it's tough to know what's going to resonate with somebody hearing the appeal. So, you know, you may need to advance a few different ones to see what's going to stick. So here they say the General Division made an error of law. The General Division considered only whether the claimant had a reasonable assurance of another employment in the immediate future. It made no finding as to whether the changes to the claimant's hours represented a significant change to the terms and conditions of her wages, and did not consider how that circumstance affected the claimant's reasonable alternatives. The General Division made an error of law when it found the claimant had the reasonable alternative of remaining employed without considering all the relevant circumstances. And that's interesting there, because they didn't just say the General Division made an error of law in finding she had reasonable alternatives. They flipped it into an error of law by saying the error was not considering all the relevant circumstances. The General Division did not consider the claimant's significant reduction in hours and earnings, This is clearly relevant to whether staying with the employer was a reasonable alternative. I found the General Division made an error of law. That means I must consider the appropriate remedy. So, congratulations, all your exceptional research and putting your appeal hats on has helped AK win. But now there's this issue of remedy. What are we going to do? So two choices again the appeal division has are send it back to the General Division to tell them to do it over again, or make the decision that the General Division should have made without sending it back. And my impression is that increasingly they are really, 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 really trying in as many cases as possible to just give the answer to the point where it almost makes no sense. And I think this case kind of illustrates how far they'll go to try to bend over backwards and give the decision. So if you want to flip. So, in this case, the decision maker goes on to say, I have the authority to change the general decision or make the decision that the General Division should have made. I could also send the matter back to the General Division to reconsider its decision. I accept that the General Division has already considered all the issues raised by this case and that I can make the decision based on the evidence that was before the General Division. Now, this is, of course, interesting because the decision maker just finished finding that the General Division had not actually considered all the issues. I will make the decision that the General Division should have made. Having regard to all the circumstances, I find that the claimant had no reasonable alternative to leaving her employment and that she therefore had just cause for leaving. So we've cut out a lot of paragraphs just for space, but the decision maker allows the appeal, but then decides I'm going to go through all the evidence and actually make a decision, finding that when I consider all the circumstances, including the assurance of a job and the cut in hours, change in all the things people mentioned, change in conditions of employment, there was just cause. Okay, so anybody have any closing sort of questions on that that AK example? Okay, in that case, we'll head on. And again, just to reiterate, we really wanted to use a real life example. So you can see in the slides, which we'll post to SCED after this, there are citations for the decisions. And so if you are thinking that we skipped over too much, you can feel free to go look them up. So that kind of concludes our run through the appeal system itself, how the appeal system works and how you go about doing it. We're now going to touch on just a couple of sort of side issues just for the sake of completeness. The first is what we call applications to rescind or amend. And I'll say that these applications, in my experience, have a whole lot of potential, if misused, to get people into big trouble because they try to do this instead of appealing when they should be doing the reverse. But in the EI world, the SST can rescind or amend a decision if new facts are presented or a decision made without knowledge of or based on mistake about some material fact. So the difference here is that appeals go up a level. You're going from one level to the next. The higher level is reviewing the decision by the lower level. Applications to rescind or amend go back to the same level. And you're basically saying, okay, I have new facts, or there was this clear mistake about a material fact. So without appealing, I want you to just go and amend your decision. A lot of people think this is an opportunity to just re-argue the appeal, and it's not. It really shouldn't be used as that, and that's not what it's for. So a lot of people get into trouble by trying to do this, thinking that they're just going to get a new hearing, and you're not. So this should be used sparingly when there really is new facts or there was a serious mistake about some fact. It is really unclear how the difference between appealing to the appeal division based on a mistake of fact and applying to rescind or amend. But when in doubt, I think I would probably take the route of appealing unless it's really clear that the application to rescind or amend makes sense. Resources. So we were going to just run through a couple of resources you can use to research. Isaac, are you able to open a web browser and go to the SST website, or do you have a bunch of stuff?
I think I can. Let me just.
So these are just tools. While Isaac sees if he can get the SST website up, I'll actually jump down a few bullets. So Canly, I think most people are familiar with Canly. I won't go over it, but it's a free service that reports legal decisions, and SST decisions are reported on Canly. So that's a good place to get them. I've noted this thing called the Digest of Benefit Entitlement Principles. That is a big mouthful, but it's the equivalent. It's basically their policy manual. So for those of you who do a lot of work with the ministry, you'll know that the ministry has a policy manual that provides more information on certain topics. This is the commission or EI equivalent. So if you just Google that, it'll come out, and it's going to give you sort of a narrative rundown of certain key topics. It's not binding, but it's the commission's view of the world, which is what they're going to follow. So it's good to know. Awesome. Here.
Have we got it?
So just to show you a few resources. The Social Security Tribunal website is not that wonderful, as you can see. But just so you know, and you can find a few things. On the far right side, under Most Requested, you can find forms for your appeal. I don't think we need to click on it, but you can get all the forms you want. You can also search prior tribunal decisions. So sometimes, particularly when you're at the General Division, you may want appeal division decisions to sort of buttress your position. That can be very useful. And then over on the far left under Services and Information, you'll see employment insurance. And if you click on that, it's going to take you to a couple of how-to guides on how to do these appeals. So if you've already tuned us out, which I don't blame you for, you can go, and here there's going to be how-to guides on both levels of appeal and how to do them. And it'll take you through, there's headings that'll take you through the different steps. The one thing I do want to show you relevant to our example is under Most Requested, under Employment Insurance Reference. Yeah, if you want to click on that, Isaac. What this does, this is a tool they've created that is going to take certain topics and list cases relevant to that topic. So antedating, that means late claims. It means backdating a late claim. But relevant for us, Isaac, if you go up, and so we were dealing with disqualification, voluntary leaving, and misconduct. So if we click on that, and then we were dealing with Section 29 of the Act. So if we go down to Section 29 of the Act, you'll see it'll list the legislation. It's going to give you a couple of key cases that explain it. It's going to give you the general principles and a bunch of cases if you really want to read a million cases. And then it's going to give you stuff on the test for just cause, but it'll actually go down into specific examples that are listed. So for example, we have cases dealing with sexual harassment, leaving to accompany a spouse or a common law partner, discrimination. And then if we go down just a little bit, relevant for us, there's a whole section here on reasonable assurance of another employment. So you can read a bunch of cases on that. You can read cases where it was considered just cause. You can read cases where it was not considered just cause. And then going down even more, significant modifications in terms of conditions. You've got cases where it was considered just cause and where it's not considered just cause. So, you know, you can kind of look for your issue and look up cases. So just one warning, this is not necessarily comprehensive, and it's not designed to necessarily help workers win. This is self-selected cases from the SST. So you may still want to do a little more research, but it's a good starting point if you need a little bit of help understanding these issues. Okay, so I think that's all we really had to look at. Isaac, do you want to, we can go back to the PowerPoint, I think, unless anyone has any questions about those. And the last resource I'll mention just on this is the Annotated EI Act. You're probably not going to have it, but it's available at courthouse libraries. And what it is it's a version of the Employment Insurance Act, but it's got a write-up after each section, a lot like what the what we just showed you, but for all sections. That's going to explain how it works and explain important decisions and this and that. So it's a good thing to look up if you have access to a court library. Okay, and then going down here, the last thing I want to cover before we free you up for the day is just a little piece on insurability rulings. So you'll remember way back at the start, we gave the caution that the appeal system we've just spent way too long talking about applies to decisions made under the EI Act. But our good friends at CRA, the tax collectors, have their iron mitts on certain issues and they're not letting them go. So key for EI claims, CRA and not the EI Commission and not the SST decides how many hours the person worked, how much money they earned, when the employment started and ended, and whether the work is even covered by the EI system. And that last bullet normally pertains to, for those who are less familiar with the EI system, the employee versus independent contractor issue. You know, generally the EI system covers employees, but it doesn't, in most cases, cover the self-employed, although they can opt into certain benefits. So here's how this usually works, just so you understand. If your client files an EI claim and it looks like there's a dispute about how much they worked or how much they earned, the commission will usually write or call up their friends over at CRA and say, hey, give me a ruling on this. If that doesn't happen, your worker can request their own ruling on whether they're covered by the EI system or how many hours they worked or how much money they earned. And the deadline's a little weird. It's June 29th after the year the work is done. So for any work done in the calendar year 2020, you have to ask by June 29th of next year. And the legislation is a little confusing because it says before June 30th, which essentially makes the deadline June 29th. This, you can ask for a ruling through CRA, or you can ask for it in writing, and I've put again the form number that you can try to use to dig it out of that catalog of federal forms. So, you know, if you do have somebody come in and say, like, you know, my employer is telling me I'm a contractor, but I don't think I am. I think I'm an employee. This is one way they can ask for a ruling on that if they want to. So if you want to flip forward, Isaac. So what's going to happen is, whether it's from your request or from the commission's request, CRA is going to spit out a decision. And it's going to say, we conclude that the worker was working in insurable employment and had 600 hours of insurable earning, or 600 hours in insurable employment, and had, you know, X dollars in insurable earnings. And where people sometimes get tripped up is forgetting to appeal those insurability decisions separately. Again, you can't show up at the SST and say, hey, I want you to take a look at the CRA decision about my hours and earnings. There's a separate appeal stream for that. And this gets super awkward because sometimes you've got appeals going in two directions. You've got to meet your deadlines and run your appeal through the EI system, but you've also got this appeals going through CRA appeals that you're waiting on. But it is important to do both. So the deadline to appeal, if you don't like what they say about the number of hours you worked or whether you've been covered by the system, is 90 days. There's a form for that. You know, again, I could give you links, but good luck trying to navigate the federal catalog of forms. So sometimes it's easier just to Google the form number and what it's called. These work way more like an investigation. There's no hearing, there's no cross-examination. They call the employer, they investigate, they get documents, they call the worker, they investigate, and then they're going to make a decision. And then this is probably beyond what you folks will help people with, but if you don't like what CRA Appeals does, technically it's Minister of National Revenue, but surprise, surprise, the actual minister doesn't sit there writing decisions, it's CRA Appeals. Then there is a right of appeal to the tax court within 90 days. So just wanted to point that little wrinkle out to just be live to the possibility that if there is a fight about hours and earnings, to really watch for these insurability rulings and make sure they get appealed in the right way. And yeah, we've just listed there are a couple of guidebooks on navigating if you do find yourself helping someone through this, am I an employee or am I a contractor situation. There's a couple of resources there. Again, these are listed in the federal form catalog. That is so massive, it's really hard to navigate. So those are the form numbers. So if you just have to pop it into Google, that should help. So I think at that point, we've run through all the things we want to cover. We still have time to take some questions if people have them, or to go back over anything that is exceedingly confusing. The last thing I should say is you may have noticed that our office has sent out to a lot of you a survey about EI and providing EI services. You know, because our impression is a lot of people don't do this, and it has a lot to do with the EI system being incredibly hard to understand. And so what we're hoping to get from you, if you can fill it out, is what we can do to better support you if you're kind of interested in helping people take some of these on. You know, in other provinces, there are way more resources for people. There are entire clinic networks to help people with EI, but here it seems a lot of people are going unrepresented. And, you know, we kind of want to get to the bottom of why that is and try to encourage you to give clients some help. So give us some feedback about what we can do to help you through that. Any thought that CERB appeals go through this system? Oh yeah, I knew someone was going to ask that. I have asked and sent emails and no one has clarified. And the confusing thing with CERB is, as we've discussed, CERB was paid from one of two places. For people covered by the EI Act, it was paid out of the EI fund. And for people not covered by the EI Act, it was paid through the Canada Revenue Agency. And it's possible, I haven't received clarification, that the answer is different depending on what pot you were paid out of. So my sense is that for people who got it through the EI system, I would at least be trying. I can't say, I don't want to say definitively that it'll work, but I would at least be trying to pursue appeals that way. And the moment I get some concrete information from somebody, I will certainly post it to the EI list so that people will know about it. Any other questions? All right. Oh, sorry, one coming in here.
Another question.
When client discovers initial denial to claim online, do you recommend a call to EI? EI has definitely been promoting that even before you do a formal reconsideration, there is the potential to kind of do like a call us and we'll see if we can fix it. So sure, I think it's totally worth a try. It can't hurt. The only way it can ever hurt is, number one, if there's confusion about whether you've actually engaged the formal reconsideration process, because there are deadlines and you have to do that, and it's a prerequisite to getting to the SST. But provided, it's clear that you're not missing your deadline to engage the formal reconsideration process, there's no harm calling EI. And I should say that, it's my understanding that as part of every reconsideration or most reconsideration processes, they're gonna call you. I think they are going to call you. So that contact will probably also happen through the formal reconsideration process in most cases. It's not a surety, but in most cases it should. Okay, well, unless there's any other questions, we can let people get on the way, and feel free to contact us both if you have any other EI questions. We're happy to take them.
Thank you, Kevin. Thank you, Isaac. There's lots of questions, lots of thank yous coming for you in the chat box. It was indeed a very good session full of knowledge, information, and I hope the participants have got a lot out of it. Thank you so much for sharing your wonderful wealth of knowledge with the participants. There's a lot of thank yous for you, if you can see in the chat box as well. Thank you, and have a wonderful evening.
Great. Thanks, everyone.
Thank you.